On November 4th, Public Consultation Notice No. 10 of 2025 was published, presenting the draft Susep Resolution, which aims to adapt Susep Circular No. 621 of 2021 to the new insurance law 15,040, set to take effect on December 11, 2025. The resolution aims to define the rules and criteria for the drafting, structuring, marketing, and operation of property insurance contracts. Property insurance accumulated a total of 95 billion reals in revenue in 2025 up to the month of August, of which 4 billion reals refers to Surety Insurance. Although it represents only 4% of the property insurance market, Surety Insurance is extremely strategic for the country's development and for our economy. This is why we have invited Ms. Jessica Bastos, Director of Susep, to join us today, and Marcelo Mansur, partner at the law firm Mattos Filho, to join us for this conversation. Jessica Bastos is a director at Susep, responsible for the Directorate of Market Organization and Conduct Regulation. Marcelo Mansur Haddad is a partner at the law firm Mattos Filho, specializing in insurance, reinsurance, and pensions. Jessica, thank you for accepting our invitation. It's a pleasure to have you with us today. To introduce the topic, I'd like you to tell us a bit about what goes on behind the scenes. Talk a little about the work done by Susep. I want to congratulate you. I think it's extremely challenging to draft a resolution proposal, so I want to start by congratulating you on the work. And if you could share a bit of those behind-the-scenes details at Susep with us.
Every time I receive an invitation to talk about this process of regulating the law 15.040, in fact about the regulatory process in general, I always find it super productive and I think it's great. It's an invitation I love to receive. Well, this behind-the-scenes work, I think everyone imagines it's difficult, but it's actually much more labor-intensive than I expected, even before I joined Susep. In general, it's a very delicate job. We're working within the economy, shaping contracts, in my case specifically because I'm a conduct regulator. So I talk much more about contracts than about the prudence and solvency of insurers. But these are contracts that can either make an operation work or not, that can enable a business to happen. So at Susep, we're always very aware of how delicate the work we do is and of the magnitude of the responsibility. So in general, it's a job we do with a lot of care. So we always do our work with a lot of dialogue. So we always strive to build relationships with all the players in the insurance market, including consumers, policyholders, and sometimes beneficiaries and policyholders. Because we're not just talking about policyholders. The insurance market is made up of various parties. And in the specific case of Surety Insurance, there are 3 parties involved. So we always seek this dialogue with all the stakeholders affected by our work, and we do this even before we have, for example, a regulatory proposal or a draft, and also afterwards. So when we are thinking about or formulating regulatory proposals, we are already having these conversations. And anyway, after the public consultation process, we also usually listen. In some specific cases, we hold public hearings to bring more transparency, especially on topics that are a bit more sensitive or broader in scope, like the consultation dealing with the associativism regulation. Last year, we did this for cargo transport, but even when we don't have a public hearing, we also usually hold meetings and discussions. So we actively reach out, really. We invite representative entities, policyholders, insurers, and clients to listen and to draw attention, especially for the board of directors. It's very useful because sometimes in our daily routine, we can't look in detail at the tables or spreadsheets we receive with contributions. So that's part of the work. Specifically in the case of the regulation of law 15,040, we have a challenge. It's even greater because the law is quite prescriptive and it brings a change, a new logic in the way we look at insurance contracts. It starts from the assumption that there is an asymmetry of information between the insured and the insurer. It starts from this assumption, not that it's written anywhere, but that's the underlying premise. So it raises the level of requirements for information disclosure and conduct for insurers. Because of this, I think it required a new perspective from Susep regarding the regulations and the insurance contract itself. So the work of studying the law, which lasted the first 3 months of the year, was quite extensive, right? So we had long sessions and discussions with everyone in the organization, with all the staff, to really brainstorm, study, and talk things through together. So there was that, and it was really productive because, in fact, the law brought new elements that, especially for Susep, we talked a lot about, for example, the reason behind it. Why does the law seek to protect Brazilian jurisdiction? Why talk about the applicable law? Why does the law go into such detail? And that's something that, for us, for Susep, was, in a way, a new experience to start thinking a bit about these issues. So the process during the first 3 months of the year was dedicated to that. It was to study a bit about what new things the law brings, what the legislator had in mind behind some of these ideas. It was really productive, but it was truly a task of shifting our perspective on this matter. And then afterwards, we would, for each regulation, after conducting this study, this analysis of the law, we would look at each regulation and then start dividing up, splitting into groups. So those on the life insurance team would look at the life insurance regulations. Those on the property and large risks team would look at the guarantee and large risk regulations and so on. That's when the specialization work began, meaning the initial diagnostic work was done with everyone together. After that, we started dividing up, each person focusing on their area of expertise, and then we really began to look at the regulations and think specifically about each one. So the property insurance regulation, I think, is the backbone of many of the regulations we're about to start adapting now. And it's quite a different regulation. The proposal is very different from 621 because the law actually brings a major change in the way the contract is interpreted. It's a much longer regulation, much longer than the old 621, and it introduces, in short, some elements that will set the tone for the next ones, although we will still need others for sure. But the guarantee regulation is one that we'll need to revisit. But anyway, I asked the team for us to do it in this order. First, damages, and then we can address the others so that we can lay some groundwork to have a foundation before we start discussing the next one. This is a bit of the work we've done over the course of this year, and now, at this point, we've already held the consultation, but we're still working. Just out of curiosity, we received almost 700 contributions. That's a lot. It really is a lot. It's among the regulations for which we've received the most contributions. I think it's similar to the work we did on cargo transport, just so you have an idea, which until then had been the one we'd received the most contributions for. Now there's associativism, which is different because, in fact, we expected to receive a very large volume, but still, now the work begins of looking at each one, justifying why we don't accept it, listening and understanding what makes sense for us to consider or not. Anyway, now begins the work of digesting what's come in. So that's the stage we're at right now. Anyway, I'm meeting with my team, with the superintendent himself, who has also been personally working on this topic so that we can move forward to the final regulation. In short, we transpose these conclusions to the other regulations. That's a bit of what we've done throughout this year.
I can imagine it's actually a much more extensive job than we think. But it's interesting, I found it interesting that you first consolidated the concepts, right? And only then you actually dedicate yourself to the changes that are necessary. Very interesting. You talked a little about the objectives of the law, right? Which really, at its core, it brings transparency. Can you share a little bit of that with us? After these first 3 months, what were the main messages that the market as a whole took away? If you could kindly sum up these significant 3 months of careful reflection on the current law so that the broader market can effectively share in this valuable insight, this direction.
Okay, I truly think that one significant issue that was really quite emblematic for us, in short, laying the groundwork for the initial conversations was about understanding the insurance contract as an instrument of economic development and national sovereignty. So it was, and also when we think, for example, that among Susep's responsibilities is regulating the contracting of insurance abroad, insurance in foreign currency, etc., there's a group there that basically does just that, right? And they had to understand, wait a minute, why are we talking about prioritizing Brazilian jurisdiction if there's a supply issue? And what if there's a solvency problem? And what if the reinsurance market pulls out? What does that mean for our need for reserves, capital, and so on? So that was the first step.
All very relevant reflections.
Very relevant indeed. And then there was this first step, which I think was to first calm things down, because there's always a shock when we're talking about such a major regulatory change. I remember back when there was the change in cargo transport, and I keep going back to that legislative process because it also really changed the logic. It changed the responsibility and the obligation of whoever contracts the insurance and so on. But anyway, at the time, it felt like the world was going to end, that insurance would get more expensive, or that there wouldn't be any supply and so on, which is a threat, so to speak, or a fear that often arises in the insurance market whenever there's a major legislative change. So there was a bit of that fear, concern. And then going back to the sovereignization system, people would ask, but what if Angra 2 became unsafe? There was always that fear, specifically about Angra 2.
In short, it was a way to give form to that fear, right?
So that's the first issue. I think there was also a major concern about deadlines, about the deadlines for regulation and claims settlement. But it's funny that the market got really alarmed about the deadlines being so short. The fear from the regulator is, why are we even talking about this? Why are we talking about deadlines? Why does the law set these deadlines? How are we going to decide when to extend or not to extend them? So there were different concerns. So there was this need to explain things a bit. Also, in the real world, sometimes at the moment of the claim, because Susep is a bit removed from the claims process, this discussion ends up in the judicial sphere. So it's a bit about bringing the discussion home, like, look, it's no use just looking at solvency, etc. We have to think about the effectiveness of this product, about how suitable this product is. If the product ends up in court too often, something is wrong. And that's justification enough for the legislator to act, for the regulator to act, and of course, always with the necessary care to avoid issues that could make the product more expensive. So you see, it's a very delicate balance, right? So there were these questions about why we're talking about deadlines, why the law talks about deadlines, why the law talks about reinsurance, and then to say, no, look, reinsurance is not an isolated operation. Reinsurance is functional to the insurance contract, so it means it has to serve the insurance contract. It's not something that exists in its own world, in the ether. Those were the main concerns, really. Why is the legislator getting involved in this feeling that, after all, why does the law go beyond what seemed unnecessary? So there's a bit of this logic of changing a little the way, how do you look at this? And to understand that contractual dirigism has been used and will always be used by states when there is a need to instrumentalize a certain sector of the economy, a certain area, a certain type of contract. So there's a bit of that, of thinking differently about this and always remembering the ultimate purpose of the contract. Insurance, which is to provide a guarantee to protect the population from vulnerabilities, to protect public infrastructure, to protect people. I think those were some of the doubts that came up at the beginning. Mainly, why does the legislator talk about this? Why do we need to talk about this? But after we talked a bit about it, it was something that started to work.
Yes. These are the doubts that really came from the regulator as well, but also from the entire market. And I honestly found that initial moment of addressing these doubts really interesting. And to digest together with the whole team, who will later have to do the work of creating all the regulations. And everything is cool. So excellent. I'm going to take a bit of poetic license and ask a question regarding the hierarchy of the rules. I noticed that Susep started using the Susep Resolution in 2025. In the past, we were used to seeing circulars. And then, so for me to understand the hierarchy of the rules, does the circular still exist, or is the resolution replacing the circular? Is there a hierarchy between Susep Resolution and Susep Circular?
No, they are actually the same regulation. We changed the name because, in general, a resolution is used for infralegal rules that are decided by a collegiate body. So there is a decree on normative technique that specifies the names, right? An ordinance is an act by an authority, a resolution is by a collegiate body, and so on. Susep specifically had a provision in Decree Law 73 of 1966, which stated that Susep would issue circulars. So specifically, Susep had to call its acts circulars, which in all other agencies were called resolutions. All the collegiate bodies, because we had a specific decree that dealt with our regulatory acts. But it's the same quorum, it's the Susep Board of Directors that deliberates on those rules. When the reform of Complementary Law 213 came, which made significant changes to the structure of Decree Law 73 specifically, that article was removed. It was repealed. So we no longer had the legal basis to call our rules circulars. And then the general rule comes back into effect, which is to call it a resolution. That's why, in fact, the CNSP level resolutions are called resolutions. Also because it is also a collegiate body. So actually there is no real hierarchy between a resolution and a circular. In fact, Susep resolutions revoke Susep circulars. And from now on, everything will be called Susep resolution as the circulars are revoked. It was just a change in terminology because of the repeal of that article from Decree Law 73.
So in terms of hierarchy, we have the federal law 15.040 and the CNSP resolutions. And then come the Susep resolutions, which are on par with the circulars that are still in effect until they are reviewed. And then they take on the name resolution. Resolution, exactly. I have one more question on this topic, which is the following. When you have a regulation that within the hierarchy is lower, but it is more specific to that insurance, which one prevails? Is it the hierarchy of is it the regulation that is at the higher hierarchical level or the one that is more specific to the topic?
If we're talking about a normative contradiction, an antinomy, the hierarchically superior rule will prevail. If we're talking about a contradiction, if we're talking about a complement, that is, if there is a circular, a resolution, if they...
It's my adaptation, that's fine.
If there is a Susep resolution which is more specific but does not contradict the CNSP resolution in any way, both coexist. Both coexist. Exactly, they coexist. But if one is contrary to or contradicts the other, the hierarchically superior rule overrides the inferior one.
The inferior one. Because one of the doubts I had when the scope of the draft resolution was defined was regarding large risks, which are currently provided for in CNSP Resolution 407. That's right. And the original text of Susep Circular 621 gave you the option either to adhere to what is set out in Circular 621 or to follow what is written in CNSP Resolution 407. I imagine that the CNSP resolution will also be revised. Yes, it will. It will be included in your review schedule, right? My question would be, what is the reason for removing this option? Because the scope is, there is an intersection. I don't know if the scope of 417 will also be expanded, just as it was with what is being revoked from Circular 621. Because we have... Let me just quickly copy this down, guys, so that I can accurately say it correctly for you. The draft resolution talks about the development, structuring, marketing, and operation of property insurance. And the one for large risks from the CNSP resolution talks about development and marketing. So there is the scope, the intersection between the scopes.
Actually, when the CNSP resolution 407 was approved, it was really about a policy choice, about setting a political guideline for management. At the time of the CNSP, together with Susep, it was a regulation that came from Susep as a rule. That's how it is. Susep is a member of the council, but there is no hierarchy among the CNSP council members. Susep is a member, but as a rule, due to its technical expertise, the regulations actually originate at Susep and are presented, put on the agenda, and reported by Susep at the National Council of Private Insurance. It was a CNSP regulation because the CNSP is the regulatory body that has the legal authority to establish policy guidelines. And Susep has a more executive role, although it can regulate the CNSP's infralegal regulations. At the time, the logic behind 407 and Manso, I imagine you've been closely following these discussions, so feel free to disagree or jump in with your thoughts. But the idea was to shift the perspective a bit on how large risk insurance is contracted in Brazil and to make possible some things that didn't exist before. So that's why it was a CNSP regulation. Not because it was operational, but because it was, in my view, a political choice, a political directive at that time to allow large risk insurance to be contracted in a different way. So that's why it's a regulation entirely based on freedom of contracting, on economic freedom, and on being able to choose one regulation or another, being able to choose however you want, but it is based on the assumption that you can only apply it if, let's say, it is proven that there was freedom in the contractual discussion in the pre-contractual stage. But anyway, it was a CNSP regulation because at that time it was a political decision to establish a political directive, really. Today, actually, unlike the proposed resolution on damages, the tendency is not for it to expand or grow in scope, quite the opposite. It's actually expected to shrink because Law 15.040 in a way equates insurance. Although it allows the regulator to give different treatment in some cases, it essentially aligns the logic of large risk insurance with other types of insurance. So there's less room at the regulatory level to consider the approach that Resolution 407 used to take, especially when it talks about the broad contractual freedom between the parties. I feel like that's still somewhat present within the limits of what Law 15.040 allows, although I don't think it makes it impossible for you to enter into contracts in the way that 407 in theory was meant to introduce. But we recently conducted a study specifically about Resolution 407, and it was rarely used, it was rarely chosen. Anyway, for reasons, I don't know why, but anyway, it probably makes sense when you're talking about large risks. These negotiations are sometimes done directly with the reinsurer, so in short, the logic of broad freedom to negotiate applies. It's even hard to prove when you're talking about sometimes negotiating the acceptance of risk directly outside of Brazil. Anyway, the fact is that it was used less than we imagined.
I also think, in my opinion, Mansur, feel free to comment, but it brought about something. It's a change in the freedom to negotiate. And for this to really take shape, you need to establish these negotiations. So it's also a process that takes some time to mature. So in my view, it's not a regulation that comes into effect and immediately causes a boom in issuances. Because the relationships with the policyholders themselves, who are considered automators in the case of surety, who are considered eligible to use this more individualized negotiation, you need to build that, and it's a process. So I would actually expect that there wouldn't be this path to follow.
But I understand then that now, until it is revised, it is in effect as long as it does not contradict the law. 15.040, it's always good to remember that what we're talking about here.
Federal law always comes first, above all, for sure. It remains in effect and will probably be revised with a reduced scope to better reflect the spirit of the law that you're bringing up.
That's right. And in fact, we actually need it to continue to exist because it provides the definition of major risks, for example, which is widely used in other regulations, including in this draft resolution that mentions the extension of the deadline for major risks. That definition is in Resolution 407. So these are cross-references that we will eventually need to adjust, of course, but yes, as long as it is not incompatible with the law, 15.040, it remains in effect. But now, notice that this proposed resolution on damages does not make it optional. It states that it applies to everyone, including major risks. So now, regardless, you can no longer choose. The option regime, I think, is now compromised. The damage regulation applies to everything, but regarding the definition of major risks, etc., regarding the coverages, including for risks, for what we call inherent branches of major risks, nuclear, oil and gas, and so on. The provisions that are compatible with 15.040 also remain in effect, in force.
And so, if any particular aspect of the draft resolution does not apply to major risks, this will be mentioned in the draft of this revision of Resolution 407. Or is it expected that the draft resolution itself will specify the exception of not being applicable?
I think that, well, maybe later I might find myself in a situation where I need to say what I just said now. That's not...
Question is too complex to be answered here? Yes.
Right now?
Because you haven't thought about it yet. Exactly.
Exactly.
I'm putting myself in your shoes here.
Yes.
Yes. And there are things that only emerge when you're writing.
Yes.
But in theory, any exception will be included now. It will be in it, in this damage resolution. In theory, we won't be making exceptions later on. But again...
I understand. That's it. So now can I take the opportunity to make a comment about this? First, I'd like to thank Carol for the invitation and congratulate you on the work you do at Susep and the whole Susep team, which I recognize is Herculean. Creating a regulation is very complex. We can see it, you mentioned, the amount of questions you get, which you have to look at, read, respond to, and consider. But even drafting the regulation itself is already a process. It's complicated, and then analyzing the request is another process altogether. And there's also the whole political aspect that you have to navigate, which you can't stray too far from, because everyone, of course, makes their own comments. While each person is looking out for their own interest, you are looking out for everyone's interest, including the interests of the system itself. I think that's important. And then touching on this point here about the 407, I think it's a topic that's sensitive for several reasons. I'll even say here that when we buy insurance, I consider myself a buyer of major risks. I fit into the scenarios that are outlined in the law. And I feel capable of discussing my policy in detail with whoever I'm contracting with. But for example, this possible uncertainty that might, which I think may be the word optionally, I already understand that. Obviously, that's not necessarily going to be the model. But let's take a specific topic. The registration of products. The registration of the product today, according to the draft resolution, and by the way, it's great that you gave that clear explanation, because I think a lot of people wanted to understand why there will be confusion, since we're going to mention a certain resolution and we won't know if it's from the NSP or Susep, but we'll learn. But the Susep draft resolution talks about mandatory registration. While we don't have mandatory registration yet, and here from what you said, registration will be mandatory because there's an incompatibility. Obviously, the rule in 407 will have to be reviewed. In my view, perhaps since the new resolution will come first, I think it's 407 that will have to adapt to the new law. So thinking about it in a slightly more pragmatic way. But this is a point that stands out, and obviously it has a connection when you think about the law, which is precisely that issue. When you don't specify which number will apply, the one that, no, but under the current rule, my product, which I consider large, isn't listed at Susep. And maybe, to be honest, I want my insurance to be different from my competitors. And I want it to be better. And I don't want it to be published. Because it's a product I negotiated, and I don't want my competitor to have the same product as mine. So I am actually sensitive about this issue. But this is a point, for example, that I think is worth looking into to see to what extent I can preserve it, because looking at it, I think there may be some discretion to decide what can be registered and what cannot be registered. Someone might interpret that under the new law, everything would have to be registered. Registered is the word. Today, it no longer has the connotation of authorization, which is great. It's simply a filing. I'm just filing it there. But this, for example, is a topic that could have some divergence between what 407 says and what the future rule will establish. So this creates a bit of uncertainty, and then you have to find the best way. When you use the word optional, it's about how you address this, whether in the current regulation, and maybe I would even prefer it to be addressed now rather than in 417, because at least it would already provide some reassurance to the market. Knowing that, in this specific regard, maybe you don't necessarily need to adhere strictly to this rule.
I think that's an excellent point, Mansur. And picking up on that, one of the points I had considered discussing with you is about the registration of particular conditions, because the general and special conditions are, as a rule, registered with Susep. So I'd like to understand a bit more about the motivation behind this. Why require the particular conditions to be registered?
That's one point. For example, when I say, oh, the law is quite prescriptive, but there is still room for the regulator to act, which I think is a perfect example, right? Because the law, it doesn't say that, it doesn't even mention product registration anyway. But there, in Article 9, it talks about the emergency sale among the contractual conditions that were delivered to the insured. And what was registered, the actuarial technical notes, etc. At Susep, the one that is most beneficial to the insured prevails. Exactly. And so this is a point that we had that 3-month conversation I mentioned, right, about the spirit of the law, etc. The famous ghostly spirit of the legislator, the spirit of the legislator. So what do we do with that? What does that mean? Does that mean the law requires all products to be registered so you can check this? No, especially because it starts, the paragraph starts by saying if there is a discrepancy. But it truly seems to indicate a rather significant kind of a much broader and more comprehensive perspective from both the supervisor and the regulator regarding the specific products being actively sold in the market. And this comes a bit from the logic, especially also from a recent movement by Susep to strengthen conduct supervision, which relies heavily on product registration. That's where it came from. Hence the logic of returning to the discussion about registering large risk products, which until recently had been exempted. The registration and talking about the registration of specific conditions. So in short, there is a bit of the logic that Law 15.040 brings and a bit of SUSEP's logic in pursuing an agenda to strengthen its conduct supervision, not just prudential supervision. So it's part of a broader movement. But we've already realized that this is a sensitive issue because the market has brought it to our attention. And so why do I say it's so interesting to listen to both the insurers and the insured? Because the market tells us that, in fact, this is exactly what you just said, right? Mansur, that in fact the insured parties don't want this, especially when we're talking about large risks, because it will reveal business details, etc. that will be exposed. So great, we can listen to the insured party. So it's very important that we listen to representative entities of major insured parties who have this concern so that they can personally bring up this concern so that we don't receive a second-hand concern, so to speak, about this. So this is a topic that, again, the law, SUSEP's mandate, is to act in defense of beneficiaries and the insured. The entire logic of the law is the protection of the insured. If the insured tells us that this is a problem for them, obviously we will listen. And that's it. We have to understand that everyone will bring up their points according to their own interests, that's perfectly legitimate. There's nothing wrong with that, not at all. But we have to understand who is speaking according to their own interests. But that's it. SUSEP's mandate is to act in defense of the insured and the beneficiaries. The law is to defend the interests of the insured. If the insured tell us this is a problem for me, obviously we will listen very carefully. In surety insurance, there are many particular conditions because the ones who determine them, which instrument will be acceptable, which instrument is eligible to guarantee that obligation, it's the insured who decides. So for example, it's very common. The policy wording comes as an annex to an ordinance. There's Ordinance PGFN 2044, which includes the specific wording as an annex. There's ANP Resolution 854, which also includes the specific wording as an annex, which is accepted by the ANP. There are public notices, all the bidding notices. Many of them also include the policy wording as an annex, which is acceptable. And each one of them ends up, the PGFN ordinance is easier, because there's enough volume to justify perhaps creating a specific registration. But the public notices, for example, where each notice has a different wording, make it so that operationally it might be unfeasible to meet the wording that the insured is demanding due to the operational process. Even for the insurer, for them to be able to do it, because then the whole system changes. They need to register before starting to sell. So they initially need to meticulously present precisely what they will genuinely require, have it officially registered and thoroughly documented, so that then they can effectively receive a comprehensive proposal and subsequently commence discussing the critical aspects of risk acceptance. This fundamentally changes the entire procedural way in which surety insurance is typically contracted, altering it a little bit from previous methods. Mainly, this involves...
That's how it works nowadays. And just to add, in this case, many of these would fall under large risks. These will probably be policies of more than 15 million reais. I'm trying to reconcile this to allow for a bit of flexibility, because I already know that the rule which says that in case of doubt, the more favorable should be applied, is only when I haven't notified about the condition. So if I notify about the condition, my issue is already resolved. That's why I think the word previously is there, but previously is difficult in this circumstance. The circumstances you mentioned, and for the specific conditions, it's even harder, right? Because my specific condition, I'll only know on the day I'm issuing the policy. That's when I then input the exact insured amount.
And with surety insurance, make it required yesterday.
Right? And there's the value of my insurance, and the speed of issuing is very high. There's the value of my insurance. I don't want to disclose which one. I can, when a client asks, I can even tell them, but generally I don't say what the value of my insurance is. I just say that I have insurance. Not necessarily, I'm talking about insurance here. IENO and lawyer, for example. So there are some things that I want, and then obviously I'm an insured party, but I think you have to listen to others. I don't know how sensitive Petrobras is regarding the insurance it buys. And Petrobras might even be a market with less competition, but if you take an extremely competitive market, they won't want others to know what the other has, like IENO, my property insurance, the insurance for my factory, and so on. Yeah.
And so regarding the issue of specific conditions, what I think about the registration is that it ends up leveling the field. Everyone is in the same boat, because for large risks, it's a problem to even register the general conditions, since often it's different for each one.
So
if we're talking especially about these native lines, it's one for each case. And then when you require the specific conditions, what happens? You put everyone in the same boat and everyone started looking at this. But again, this is a topic that we are actively reaching out to policyholders so they can tell us if this is a problem. And it's funny, this Petrobras issue, everyone mentions this to us, specifically about Petrobras. I met at an event, a Petrobras employee, and I said, look, I need you all to reach out to us so we can have a meeting because your name is coming up everywhere. And he laughed and said, no, we'll talk and all that, because that's it. Petrobras it's mentioned a lot, exactly in that sense, right? Anyway, there are specific products, but this is a topic we're very sensitive to and we really want to listen, especially the major policyholders.
I think that, sorry, Mansur, there's a point. It's that maybe the policyholder doesn't have access to this operational side of bringing, okay, I'll bring here my requirements for the clauses and how the insurer will operationalize this so that it can meet their needs. So maybe, of course, it's important to listen to the policyholder to get the perspective that Mansur is bringing, but also the insurer, just to understand operationally what this means in the contracting process.
I use the example of Petrobras because it's one of the biggest insurance buyers. So if you take the largest buyer in Brazil, you look at a company like that.
And their insurance program, the contracting and renewal process is a learning experience for anyone who will read it after studying. So actually, it's a great example. But it was funny because I came across it by chance and thought, hey, tell me if
it's true. It will be heard.
But the insurers have already approached us, both representative entities and individual insurers. And we make sure to listen to everyone because we have a very heterogeneous market.
Of course.
There's no point in talking only to S1, to insurers from banking groups. We're also listening to season 4, season 3, right? And then specifically about this, about the difficulties, sometimes operational difficulties with the registration and other points as well. But this is a topic we've definitely been hearing about.
Great. It's to ensure that everyone is on a level playing field, right? Excellent. Well, so our goal today, right? And we've already dived headfirst into this, is to look at the draft resolution, which refers to property insurance, which is much broader from the perspective of surety insurance. And in this regard, one point that has generated some discussion and is a particular doubt I have is about the policyholder. The law states in Article 24 that the insurance will be stipulated in favor of a third party when it guarantees the interest of a holder different from the policyholder, whether determined or determinable. And then in Article 1, as mentioned in the Civil Code as well, it talks about legitimate interest of the insured so that the insurance can exist. And in the draft resolution, we have in the annexes with the definitions, which I thought was great, by the way, it really helps a lot. So that the entire market adopts the terminology, the distinction between policyholder and group insurance policyholder. And stating that the policyholder then is the individual or legal entity that contracts insurance with an insurer in favor of a third party. I wanted to understand in Susep's view, should the guarantees principle be considered the policyholder or not? And if not, will this be addressed in any specific future regulation?
Yeah, I heard about this question. I had never thought about it before. I think they are different types of insurance. And I don't see any sense in trying to equate them because it's not as simple as saying that the principal simply takes out insurance to guarantee someone else's interest. After all, he is directly involved in that contractual relationship. It's his performance, the fulfillment of his contractual obligation that he's seeking insurance for. He provides the counter guarantee. So in that sense, it doesn't seem to me that these are equivalent figures. And I don't really see much sense in equating them. I don't see any interpretative or practical benefit in doing so. I don't think they are the same figures. I think it would be very simplistic to just say that he takes out insurance on behalf of someone else because that's not the case. Anyway, he is personally involved in this. He provides a counter guarantee. It's his obligation. In short, it's his action that could eventually trigger the claim. So I think they are different figures and I believe they have different consequences. Anyway, obligations of disclosure, etc., they are different figures and I don't see much sense in equating them.
So I also received this question from Carol. I had the same reaction as you and used it. I think the same argument. I said, looking at the first article, I already think it's because as the policyholder, I take out the insurance in my own interest. Because I'm the one who wants to participate in the bidding, I'm the one who wants that contract, right? But the beneficiary, I mean, the person who will receive the insurance, the insured, is someone else. But I can't see it as a stipulation. And if that provision, which I don't remember if it applies to individual cases, the one that says I can file a lawsuit, with a lawsuit in the name of the insured, the policyholder can, if that article applies. In this case, for me, any argument falls apart because I could never file a lawsuit in the name of the insured. I don't know if that provision applies only to group insurance or if it also applies to individual insurance, as they call it now, or as the new law or new regulation calls it. But for me, if this provision applies, it falls apart because I could never. The policyholder filing a lawsuit in the name of the insured, it's the opposite. He
would have a conflict of interest, right? Exactly, totally. If this were to proceed, my interpretation is that you would have a conflict of interest, even in other responsibilities he has. Because in an extreme case, the policyholder has no interest in a claim being paid at the limit because he will have the right of recourse and he will be the one liable for that amount. So, yeah, good, the doubt is cleared up. No.
But look, I am certainly not the judiciary, and well, I just simply say, like, you never know how the judiciary might interpret things anyway. But I don't see any reason to equate these two figures. Now, I think they are treated differently. I think there are different consequences, the behavior of one and the other in the execution of the contract, but that's it anyway.
But that's an important point. I agree with you that the final say will be with the judiciary, but I think the role that can be played, and I think I heard this from you at the beginning, which I found super important, is that the idea is also to revise Circular 662 and create the new law, which will now start being called a resolution. And this is going to be very important because some of the doubts that arise are precisely because when we look at surety insurance, it is not subject to the law of large numbers. It is tripartite, unlike many others. So it has some elements, including in the provision of information, that are different. And so we need to have some different treatment regarding this.
That's an excellent point, Mansur, because it would be an opportunity to reduce litigation. If the revision of 662 brought clarity, precisely in this dictionary of definitions that I like so much, I think that including, I'm not sure if in this very one, because since surety insurance is under this umbrella, in the very list of definitions, it could already resolve the doubt in this same draft resolution. And maybe that would significantly reduce overall litigation costs in the long run. Well, regarding the preservation of the policyholder's rights, I think that perhaps focusing on the client should be the main reason behind all these changes, putting the policyholder in the position of the client, and then bringing this to surety so that the guarantee instrument is effective. The rights of the beneficiary of the guarantee, here in our case the insured, need to be preserved regardless of the actions of the principal of the guarantee. And then, under this principle, there is the issue of the premium that the draft resolution brings up in Article 59, which concerns the first installment. It automatically terminates the insurance contract unless otherwise provided in the contractual provisions. So that's great, because I imagine that in guarantee insurance, there will be provisions to the contrary in the contractual conditions. But in Article 61, when it talks about default on the other installments, it doesn't do that. It doesn't create this space for the contractual conditions to avoid the consequences, which is the suspension of the guarantee, which would be the default starting from the second installment. And here my concern would be that by not doing this, Article 61 could weaken surety insurance as a guarantee instrument because it is placing the default in the payment of the premium by the policyholder, impacting the insured's rights by suspending a guarantee that was provided.
On this point, you see, that's why I said at the beginning, I still don't know if I will eventually need a specific regulation, except is there any regulation that addresses this here? Because in the new guarantee resolution, we will eventually have to introduce specific rules, because I agree with you. The insured cannot be harmed by the policyholder's lack of information, in short, delays in premium payment, etc. But the truth is that maybe, and this must have come up during the public consultation, I admit I don't know specifically about this detail. if it came up during the public consultation, but it must have been seen, it must have come up, and maybe it's just a matter of creating a similar provision for the other installments, because after all, nothing prevents it. In fact, it might even solve the issue of that short-term table in auto insurance if the insurer could include in the contract a contractual provision stating that it will not suspend the coverage even
for the insured. That's great.
I don't see any incompatibility with the law in the insurer doing this. Maybe a similar provision is needed when we're talking about the other premium installments. To me, it seems like the logical consequence.
Yes. So
we'd need to go back to the resolution, but maybe it can be solved simply by
including the same phrase.
The same phrase.
Unless otherwise provided.
Yeah, because nowadays, I mean, until we have the new rule, I think the solution is for the insured to ask for proof of payment of at least the first installment, because that's what I'm going to do. I want the policy and the proof of the first installment, because right now the insured feels insecure. How am I supposed to know that you paid? And then it's even a matter of legislative technique, because in the previous law it said if the premium is not paid by the insured. Now it just says if the premium is not paid, and in this case the one who pays the premium is the policyholder. So it was relatively clear that it couldn't. So it gets a bit muddled, and unfortunately it's up to you to sort this out at the regulatory level.
I think that in general, acts of leniency by the insurer towards the insured regarding late payments, etc., are perfectly compatible with the spirit of the law. And many insureds, as soon as the law came out, came to talk to us thinking that we would no longer be able to use the short-term table and so on, that the short-term table, I know that in the past there was a lot of controversy, but basically it allows that if the insured has paid more premium than the period covered, the coverage should be maintained proportionally to the amount of premium they have paid. And then she said, no, but the law obliges me. If there is a late payment on the second installment of the premium, if we're talking about an annual premium divided into 4 payments, to suspend the coverage at that moment. I said, no, wait a minute. It's not possible that this is the logical consequence. I think it's perfectly compatible for the insurer as an act of goodwill to include the so-called short-term table in its policies, stating that if you paid 50% of the premium, you'll have 6 months of coverage, even if the default happened in the second month.
The draft resolution addressed this point.
Right.
So, exactly. There's a sole paragraph, something there that brings up exactly this, right? Yeah, saying that it can be maintained.
In general, I think acts of goodwill by the insurer regarding default, etc., are compatible with the law. Yes. And I do think this adjustment belongs in the resolution to make it clear that.
But then a bit of guidance from your side is needed. And that's where the guidance comes in, which is the institutional part, the regulator's strategic policy.
Because even though the initial installment is fully secured, the subsequent installments are quite vulnerable with the present wording, unfortunately. So they'd have to keep asking for proof of payment, and that weakens the insurance as a guarantee instrument compared to competitors. Because it starts to become more bureaucratic. I think you already touched on this point, but I think it's extremely important for us to address it, which is regarding the introduction of the risk questionnaire in Surety Insurance. The risk questionnaire, I understand the intention of the law. When it says, look, I want you to think of everything you want to ask, that you can interrupt your refusal period as many times as you want. Ask for as much information as you want. Really understand the risk, because after you accept it, I don't want us to revisit this issue. So in this spirit, I completely understand the creation of the questionnaire, but within Surety Insurance, because of the relationship between the party presenting it and the one who needs to be guaranteed, the insured, he says, look, the instrument I will accept. The obligation that needs to be guaranteed is this one, and the way I accept to guarantee it is this. And these are the eligibility criteria for the issuers of the guarantee. So he lays out the rules of the game. But the one who provides the assurance for the insurer to understand their underwriting risk, in my view, and here I'll make a disclaimer because there are other specialists in the market who have a different understanding, is the principal, because he is the one who will be able to explain why he has the technical competence, bringing all the track record of performance in similar projects, for example, in a performance surety bond. He is the one who will have all the financial information, financial statements from recent years, so he can demonstrate that he has the credit capacity to take on that contract. He is the one who will have to justify how he arrived at that cost. So, talking about the step-in clause, the importance of the insurer understanding in detail how he put together the budget for that project. And so my question here would be, the completion of the questionnaire in the surety bond, there's no way around it because it's required by law, right? So, and it's filled out by the insured or by the applicant. How do we apply this in the context of the surety bond? I have a huge doubt about this. And to reflect on this subject, because the information comes from the principal. The principal is not the applicant, nor is he the insured. The insured can say, look, this is the guaranteed obligation. These are the eligibility criteria, right, for the issuer. And the instrument I accept is a surety bond, bank guarantee. These are the clauses, and here they are. And then the contractor, the principal, needs to prove to the insurer that he is able to fulfill that contract by providing all this background so that the insurer can then say, look, I have underwritten the risk, I agree. So it's a mix of elements that come from the insured and elements that come from the principal.
And in the specific case of surety bonds, especially if we're talking about very large and complex projects or significant performance bonds, it is often actually the insured party who meticulously sets their own precise conditions, and the insurer then carefully adapts accordingly to meet those requirements. So I understand in that case. And then I would need to think about it with my team and the other board members. But I understand that in that case, what? The one step back. This rule, I think its essence is a rule of loyalty, right? That you improve the contracting environment and lay out all the terms there, and then whatever was discussed and agreed upon. At that point, you can't go back anymore. So I think it's a rule of loyalty. In short, bringing contractual good faith already into the pre-contractual stage. I don't see much of a problem. I've never received anyway as a supervisor and regulator of insurance this issue regarding surety insurance, because it seems to me that it's a contract that to the extent possible, the terms are well established precisely because the insured party demands it. To the extent possible, because again, there are things there that simply aren't known. Anyway, sometimes it's the basic project that the insurer is guaranteeing, and that's part of its risk activity. I understand that in this case, this rule would be intended for the insurer-contractor relationship because it requires everyone insured that the contractor, who is obliged to answer everything, the insurer, to ask everything it needs to know about the contractor's financial and economic capacity, and that it can't revisit this issue anyway later on. But I need to think this through a bit more. How would this work specifically in the case of surety insurance, since I don't really think this is even a problem in surety insurance?
It's because, and I think this is an important point, there are two things. The law was made for all types of insurance, and it didn't pay attention, and it wasn't its role to pay attention to surety insurance, because that's not the purpose of this law. The lack of information has always existed, and we live with it. It's been a long time. If there's anything to change, it will be in the possible new 662, which I think, but also I agree that when I'm looking at the information, it's one thing to impose conditions, right? So the insured says, this is what I need to have guaranteed, that's it, right? The bet has to pay off. The Office of the Attorney General of the National Treasury says what it wants, right? But the financial condition that I'm guaranteeing, which is the risk of, or performance risk, which I don't know if you know how to produce, you have the capacity to deliver that product or build that project, or the financial capacity to not become insolvent in 6 months. This information is for the applicant, the insurer, and I will want this information included in the risk form. Do you have any protests? Do you have, I don't know what, have you ever filed for bankruptcy protection at any point? But I think there will be an appropriate time to do this, if necessary. I think you'll have to look at it maybe, but it's more likely not than yes, because we already deal with this in a certain way. Since the assumptions are already in the law that you can't lie, you have to be truthful. What we have now is the questionnaire. But the questionnaire just mentions one word, the insured, those things. That's where I think you can fine-tune the details and say, here it's not the insured. The one who will provide this information is the policyholder. But then you need to look at 662, the new 662. Yeah, what?
I think is this like definitely what I don't think. It's that the law creates the obligation for the surety insurance company to make a questionnaire for the insured, definitely. That's not what I think. What I think is that if you're thinking about preserving this spirit of loyalty, applying this logic to surety insurance, it's about a relationship between the insurer and the policyholder where the insurer asks for everything it needs to know from the policyholder, questionnaire, etc., before taking on the risk.
That's the only point. And I agree with you all, okay? The only point, or rather 2 points I still have about this issue, are that regardless of whether the questionnaire exists or not in Surety Insurance, the omission of information by the policyholder could not, and today does not, harm the interest of the insured. So the existence of the questionnaire is not serving the purpose that by law it is supposed to have. So it might bring a bit more of maybe more bureaucracy for risk underwriting, with everyone having to think about the questionnaire for each type and so on. It's going to be a huge effort for the industry. Maybe a bit more delay as well, because the policyholder will also have to fill out a series of things that today they don't need to in an insurance policy that's usually contracted in a short period of time. And then thinking about it, I found that event you held at the central bank really interesting, where you mentioned that 38% of all the investment of all the public administration resources through the municipalities. I didn't know that number. And when you think about it, the municipalities' projects are all automatic contracts. Imagine the requirement for a questionnaire from the policyholder within this automatic issuance flow. So you might eventually include a questionnaire for the policyholder. You could end up making the smooth contracting process unfeasible through the platforms that currently operate and serve those 38% of public administration investment resources.
But you touched on an important point. You see, talking to a specialist, that's a good thing. The consequence can't be that, right? Because the consequence could even have another consequence. I might ask for additional collateral on your counter guarantee because you lied to me or didn't provide the correct information. But I shouldn't go as far as to annul it. That's why it wouldn't be a failure on the part of the insured. It would be a failure on the part of the principal. So since it's a failure of the principal, it doesn't have consequences as if it were a failure of the insured. The question that remains, I think, is why do I need the questionnaire then, if it doesn't have any consequences? But I think I'll let you think about that with your team, how to do that.
Yeah, perfect. That's exactly what I tell Paolo. I don't see this as a problem in Surety Insurance. The logic of contracting and eventually the information symmetry is completely different. In the tripartite relationship anyway. There is information that's not there, regardless of whether you hide it or not. And if someone did hide some information, the adjustment is made in another way. So that's it. We would need to see if any adaptation is necessary, because it seems to me that this issue, which this article of the law wants to prevent, isn't really a problem. In quantitative insurance, there are other issues, and those are the ones for example, Jessica, as a director today, would like to address. That's the point. Related to the issue of loss expectation bias, etc., which I think brings more litigation, but this isn't an issue where I see we gain much by trying. Simply transposing it, because there doesn't seem to be a regulatory problem for us to solve, specifically for Surety Insurance.
I even think that regarding the expectation of a claim, the new law actually reinforced the need for timely reporting. Yes.
Yes. The problem, I think, and here stepping a bit away from the question, I think it's worth us reflecting more on how the process of notifying the expectation of a claim often becomes. The litigation itself sometimes becomes an anticipation of the claim. Anyway, I think, again, it's worth reflecting on how this procedure helps or hinders, because sometimes it actually brings the claim forward. Depending on how the insurer handles or presents the issue, this can happen. So sometimes it brings it forward, or
that's an interesting perspective. I had a more positive view regarding the expectation that the insurer would then have the ability, as a third party, to mediate this relationship, right? Which is, the reason for the expectation to exist is that it can mediate and eventually help address, and I don't have the statistics, I can't think of them right now, but it's an interesting topic. I hadn't thought that this could speed up the claim. My view was more positive regarding the expectation.
In the ideal scenario, that's how it is. In the ideal and healthy scenario, the insurer helps mediate this relationship, provides guidance. So, in short, the insured notifies that there might be a problem there, whether or not to make advances anyway, in an ideal scenario. But sometimes this ideal scenario doesn't happen. So in this way, the exchange of notifications happens, and the insurer needs to seek information from the contractor, for example, to confirm, and then the contractor gets alarmed. Anyway, not that I think it will be resolved through a resolution, for example, but it's a procedure that sometimes takes work. It anticipates a litigious environment, especially when the relationship isn't healthy.
I also like to look at the insurer with this partnership they maintain with the contractors of underwriting not just the individual risk, but a portfolio of contracts. It's a more 360-degree view of how well that contractor is performing. So if they're receiving an isolated claim in a portfolio of several contracts, that has a certain interpretation. Now, if they're receiving claims from different insured parties across various contracts, this perspective, which is often one the insured doesn't have since they hired that service provider for a specific task, but the insurer, who has been supporting them in several contracts, starts to have a broader view, a zoomed-out perspective of the situation the contractor might be facing.
I think that's the real beauty of surety insurance. I think it's a fantastic instrument because the tripartite logic and the alignment of interests it allows, I think it greatly improves the contracting environment. Anyway, the possibility that, as Mansur mentioned, it's not subject to the law of large numbers, the possibility for all parties involved to pursue zero claims. I think it brings, especially when we're talking about public infrastructure guarantees, a real benefit to Brazil, doesn't it?
Absolutely, that's what everyone wants. Well, I think this issue of the questionnaire, I understand it's a topic that needs a bit more reflection. I'll just share with you a bit of the conversation since I work as an insurance broker. So I talk a lot with the insurance companies, about how they're preparing so that we can guide the policyholders and insured parties in this regard. And the question of whether or not to use the questionnaire seems to be a recurring issue in the market. Whether it's applicable or not, who thinks it should be done, who thinks it shouldn't be done. The only point I might add is that we should intensify this dialogue a bit, just so we can avoid having the insurance companies do extensive work. Because there are so many types and applicability could potentially cover absolutely everything. So if you think about all the information you need to collect for every possible scenario, it can end up being quite extensive. And also investment in technology. If someone decides, look, no, it's mandatory, we have to have a questionnaire in our systems by the 11th. This could mean a series of investments, both in human resources and technology, for something that I think it doesn't fulfill the legislator's intent, which is to say, look, ask everything up front, because later you won't be able to revisit this topic, my friend. Putting it plainly, in Portuguese, which wouldn't be applicable to surety insurance. Well, this is really interesting. I think there are still a few points I'd like to discuss. One would be regarding automatic renewal. The law states in Article 53, saying that in insurance policies with automatic renewal provisions, the insurer must, up to 30 days before the policy ends, notify the policyholder of its decision not to renew or of any changes it intends to make for the renewal. So the existing law clearly stipulates that even in situations involving an automatically renewing insurance policy agreement, changes can be readily made, and furthermore, the insurance provider possesses the right to formally request and implement such modifications to the policy terms and conditions. In Article 47 of the draft resolution, we see a more detailed approach, stating that automatic renewal is characterized by the tacit extension of the insurance contract for the same period. And here it is with the maintenance of the insurance conditions without any changes. And then in the first paragraph, it further states, if you intend to change the terms, do it as a non-automatic renewal. And then in paragraph 2, it says, look, but if you did it as automatic, I'll read the text, that's my interpretation, okay? In insurance contracts with a provision for automatic renewal, if the insurer is not interested in renewing or intends to make changes, it must notify its decision to the policyholder with at least 30 days advance notice before the end of the insurance term. So in my interpretation, if you intend to make changes at the time of renewal, treat it as an automatic renewal. But if you didn't intend to, but for some reason you have to make a change, you will have to notify the policyholder about this change 30 days before the end of the coverage period. And then with surety insurance, we run into an issue, which is for judicial surety insurance, and for many, Resolution 662 stated here, look, make the policy period match the risk period. But if you don't, make sure you are obligated to remain on risk until the risk expires, and not until the end of the policy period. This creates a scenario of successive renewals, which we call in the market automatic renewal. And in judicial surety insurance, this ends up becoming a common practice. Even in the Joint Act, there's a specific clause that brings this same term of automatic renewal. In the PGFN ordinance, I think it refers to renewal, successive renewal, which in my opinion is an analogous term. And so the point is, with renewals, two things can happen. First, the update of the insured amount. And second, the renegotiation of prices and commercial terms, which is with the policyholder and does not harm the insured. But this is known in advance, and then the first paragraph prohibits this from being done automatically. But if I don't renew automatically, I don't provide comfort to the insured. Because they'll say, you're not required to renew with me. Will this insurance last until expiration? You won't necessarily be required to stay with me until the end of the process, which goes against its principle of protecting oneself in this regard. And so this is a question I'm also bringing up for us to discuss a bit, right? So these are my questions, right, regarding the resolution that refers to property insurance. Does it already manage to anticipate this, or will we have to wait for this to be addressed in a specific regulation? Yeah.
Ideally, this will be addressed in a specific regulation, because otherwise we'll end up not having any specific regulation at all. Yes, all the particularities, exactly. And I think that in this regard, the logic of the current 662 works very well, and it's compatible with the law, I think. So I think that at this point, the most likely scenario is that we'll keep this logic, I think, that already exists today in the 662. Anyway, I don't think we would bring now a specific rule for surety insurance for this damage resolution, because the idea is not, well, it's to keep having a guarantee regulation.
So will there be 2 Susep circular resolutions, or will there be 3? I'm thinking here about the hierarchy for a general one.
Maybe I have a way to solve this. Especially because, and this is well understood, there will be a change. It won't be now, but we'll have to live during this period with 662, the new law, and the Susep Resolution. I think we can try to interpret it in the sense that there is no conflict of laws and that they are complementary. We're talking about an insurance where the relationship is between the insurer and the policyholder, not the insurer. And because when I change, let's see, when I want to change, automatically renew, changing the conditions, it's not with the insured, it's with the policyholder. And this rule in the law, we're talking about the insured. So I'm trying to build a line of reasoning here. The importance of the insured as well.
Right, Mansur? But the premium won't change. I'm increasing, I'm benefiting.
Him. I could even reduce the insured amount. Yes, you could. But it will never be. It's just that reducing the insured amount, usually the insured asks to give their okay, if the deal is well done. So he will take part in this process. So one of the ways to perhaps have some peace of mind and seek an interpretation is that this is much more clearly set out in the law and in the new resolution of the
SEB, in the relationship between the insured and the insurer, and not necessarily with the policyholder. It's one of the, if I were a lifeline for someone to cling to, I would use this to reassure the market, which it does. While there is not a reform of 662, we can coexist peacefully with these 2 regulations. One is updated and the other is not only regarding this point, but maybe even other points we're discussing.
And then obviously you'll need some time to figure out how you want to handle this issue.
It's important to remember that 662 has not been revoked.
Exactly, that's why.
It still exists, after all, in what is compatible with the law, and I think for the most part it is compatible with the law, and it coexists with the damage resolution. Remember, circulars and resolutions do not have a hierarchy, and they coexist after all. And
since it is more specific, it prevails.
In my view, it is specific.
And so I know that at the beginning I said, and now it might seem contradictory, but at the beginning I said, oh, this is a specific regulation anyway. But it's because in this case we have certain figures and specific terms for surety insurance that will need to be addressed in a specific regulation and will continue to be addressed today in 662. What I think is the main benefit of the update to 662. It's less about, well, adapting the law, but more about bringing clarity to what the law applies to in the logic of principal, insured, insurer. And then we'll be able to clearly state things like this. Here we're talking about the relationship with the insured. Here we're talking about the relationship with the principal. And I
I think there's a point you mentioned at the beginning that here there's no antinomy.
The
We're not dealing with something that's the opposite of the other. I think we're...
Yes, there's less antinomy than we think, right? I think sometimes I've often seen a certain anxiety in the market about seeing antinomy where it doesn't exist. The rules coexist, they can coexist.
I'm a bit hesitant to make this comment, but I'm going to say it. It's because, in my opinion, I believe that this first paragraph is an antinomy, because if there is an intention to change the terms of the insurance contract, the renewal must be carried out in a non-automatic way. So that's not an antinomy, because the intention to update, for example, the insured amount, the intention.
But in relation to the insured, not in relation to the policyholder. We're trying to get around it here. I don't know if Jessica has a different reasoning, but I would use what you're reading in the context of the direct insured. In surety insurance, that's in relation to the policyholder, which will impact the insured. I'm really desperately trying to find a crucial lifeline right here.
No, actually.
You have? I don't see it, but anyway.
Well, I'm just trying to carefully consider and think through this here for a moment.
When only the engineer comes to put you to sleep, maybe the engineer is wrong.
On the contrary. I actually think...
It's a much clearer and more insightful perspective than ours. Clearer, indeed.
Exactly. But anyway, it's a point for us to reflect on. If it's worth already making a point here, because again, right, I think that's the principle. We shouldn't harm the policyholder. And in surety insurance, it's important to have the perspective that the insurer can't just walk away from the risk.
Certainly, this would be easily addressed in the specific resolution. The question is how we deal with these few months until it comes out. I keep thinking here, I've already had the idea of issuing about 5 circular letters during this conversation to clarify things for the
market, which is a new instrument.
Is that correct?
It already existed, but I truly think that its application was far more restricted, and consequently it was utilized much less frequently. We've been using it a lot for these explanations in this transition mirror of the
law. Is it the normative instruction that you're going to call it? What's the name? The
circular letter. It's a communication from us directly with the market. We send it out, and since we're going through a period of a lot of transition with many questions coming up, we've been using the circular letter to reassure the market. It doesn't have any normative force, but it helps everyone feel at ease. It's
that I think I saw in some regulation that there was the creation of a normative instruction, just like, for example, Previc has. I thought Susep had one.
No, this circular letter doesn't have normative force.
But however,
it's
guidance-oriented. I think it's excellent. When you feel that there's excessive anxiety that's blocking the business, use this kind of tool.
Well, I think we're reaching the last point, which refers to the clawback clause. Our perspective on the influence.
Isn't this really the very first time she's ever encountered this particular question?
I don't know, let's see. It's our perspective on the draft resolution about the clawback clause. And here I'm referring to the indemnification section of the draft, Article 88, where it states that for indemnification purposes, payment in cash, replacement or repair of the insured object, or the provision of services are allowed, without prejudice to other forms contractually agreed upon, or by agreement between the parties. So my first question is, I understand that clawback would be other forms contractually agreed upon. It doesn't fall under provision of services, repair of the insured object, cash, or replacement. Because if it did fall under any of those, then there would be a series of adjustments that would need to be made. And that would require significant changes. So for that reason, this is the first point I wanted to discuss with you. If you think that, let's go by elimination. Well, cash? Definitely not. Replacement or repair of the insured object. Or the provision of the service?
That could be the case. But again, I think it's similar to that conversation about policyholder and policy taker. We don't gain anything by trying to fit one thing into the other. Anyway, the repossession specifically has a very particular framework, and this was already a point we were considering revisiting, for example, 662, when the bidding law was enacted, to see if any updates were needed. But it has a very specific framework, and today it's widely used in private contracts. For instance, the Minha Casa, Minha Vida program makes extensive use of the repossession clause. But if we're talking about public contracts, we definitely gain nothing by trying to fit it into Susep's damage resolution framework. Repossession, in short, of a public work, because it follows a logic of financial and budgetary allocation anyway, great. That's it. I think we don't need to try to fit something into an instrument where it doesn't belong, and eventually it will be addressed. Damage resolution, as it stands today, isn't even specifically addressed. There are some issues that, depending on the type of repossession we're talking about, are specific to those involved in public policy. For example, the MGI is addressing this, and I think there is regulation regarding repossession in cases of public contracts. Anyway, I think this topic will be addressed. There are many ways repossession can take shape, right? It can take many possible forms for us to consider and try to fit into a...
My primary concern would be regarding the crucial surety bond. It is specifically subject to this particular Susep resolution concerning damage insurance and any potential non-compliance. That is precisely why this significant effort to thoroughly reflect on the entire matter is so important. Because the next point we have, and this one is also key, is the following. In paragraph 2, it says that if there is provision for more than one possible form of indemnity payment, the definition of which form will be adopted, in the event of a claim, must be made by agreement among 3 parties. Today, the insurer decides whether it will take back the asset or pay 100%. We've already
talked about this. This is a controversial topic. But anyway, it's another point I want to mention. I think this is a controversial topic, and it's addressed in very specific spheres, in very specific definitions. So for example, the very interpretation that the insurer decides or not, etc. It's something that, anyway, I think we've discussed a lot.
For sure.
Back during the financial reform agenda, and it was a consensus that couldn't be reached. We didn't get there, we didn't build that consensus on how to interpret Article 102 anyway. So it's to request a resolution from SUSEM to settle this controversy.
But then, for example, if it's included in the public notice, like it was in Mato Grosso, that provision, there it already came.
But when it's public, since we use the bidding law, I think it becomes, we're talking about a law, a specific law. I would perhaps rely on the bidding law, which has a rather ugly framework. Obviously, we discussed this a lot. I would have liked to change some things in that law. It didn't work out, but we have a framework and we can't just ignore it and wait to see what will come, if necessary, from the new 662. Now let's think about a specific case. So it's a resumption clause within the construction of a building. In that case, we don't have the support of the law. So we're going to be stuck in this debate. I think the closest thing would be the service, but to me the service is the guarantee provided by the insurer. Because I might be buying equipment, I'm going to deliver the elevator. I don't know. There wasn't enough money to put gas in the car to deliver the thing, and so on and so forth. It's not necessarily I went there and delivered the missing fuel to finish this, or I delivered the raw material that was missing. So it's not necessarily a service, but the only word that could fit here would be service to make it work. But like this, we're going to have to find the comfort to say, look, maybe I'm not falling into that trap, but we'll manage to find that comfort.
It creates insecurity for workers with chaos resuming ops under contracts. Huge.
In a private contract, let's say. Yes, because I agree.
Why am I bringing this up? I'm now stepping into the insurance company's shoes. Because if it's classified as a service provision and not as contractually agreed forms, Article 89 only covers everything that needs to be met when it's through service provision. And then, what are your criteria for choosing the provider, etc., maintaining a network of accredited providers, and so on? And then, as the insurance company that's operating there, right, serving this group of policyholders, it asks itself, well, do I need to adjust this here? Do I need to adapt to this entire Article 89 or not? I'm not sure if there would be any way to... I don't see any benefit in classifying it as a service. I think referring to it as contractually agreed forms preserves what has already, at least initially, been working. This is the demanding market, right? You're convincing me to move the surety insurance regulation to the front of the line, because that's certainly it. We don't intend to use the ANS resolution to address issues as specific as repossession, etc. So maybe we need to move ahead in order to, well, there you go. Then I hold an event about auto insurance and everyone ends up convinced that auto is the way to go. It's just an event about auto insurance, folks. But anyway, I think an important message to make clear is let's not try to squeeze everything into this resolution. And it's important that the market holds back a bit of its anxiety and understands that there will be specific regulations.
That's it. I think that's the best news the market could have. That there will be, that we have to wait to make changes in the appropriate regulation, that we shouldn't look 100% at this and keep working based on this foundation.
Exactly. And note that this is different from saying there will be a regulation that will revoke this one. It's saying that there are specific frameworks that require a specific focus and care in a dedicated regulation, which will make it clear that it has a different process, it has different names, and so on. It's different from saying, oh, there will be a regulation that says the damage regulation doesn't apply. That's not it, but it will bring rules that are needed, in short, for specific frameworks.
Yes, because a lot of what's in the damage regulation, as you've already mentioned, is in the law, and the law applies to everyone.
Exactly.
So we're going to have to, which in a way, going back to the first point, it directly affects 407, although the law is more principle-based than 407. So there might still be something left of 407.
I also think there might be something left. And I know sometimes there's a huge anxiety, like we've gone back to the era of standard clauses. There won't be any more room for negotiation. The law does not make broad negotiation between the parties impossible. It definitely does not. If you can, great. I think the law just assumes that it's not that simple. And therefore, in the rules for interpreting the contract, etc., you have to start from the assumption that this is not what happened. But again, I think the law neither enables nor denies the possibility that this has happened or that it could happen.
I think that's the second piece of good news, and it's important for the market.
So with that, we wrap up our conversation. I really want to thank you from the bottom of my heart for your generosity, both of you. Sharing such unique and robust knowledge like this, I learned so much from this conversation today, and I hope it will be very useful for the market, for policyholders, and insured parties. I hope it was as valuable for the whole audience as it was for me. I'm truly grateful. I leave here feeling honored to be at this table. Thank you both so much. It was incredible. Thank you, Carol. Well, I'm calling you Carol. Of course, it's Carol. And thank you as well, Manso, for the conversation. As always, excellent and very productive. I also feel like I'm leaving with a lot to reflect on and think about. So it was very important for me. Thank you as well for the invitation, and our doors are always open for more conversations. Absolutely.
I'll definitely invite you again, Jessica, for sure. Thank you as well, Carol. It's a pleasure to be here with you, Jessica, and I have to say that I'm also learning a lot. I think we all learn a little bit every day. And this interaction is very enriching. Each person has their own perspective and area of expertise, and when you sit down with someone like you, a specialist, you have a much more strategic vision than we do. We have our own perspective. It even reminds me of Dr. Ari, who passed away a few days ago. When he stopped practicing law, he commented, "The fact that I stopped being a lawyer opened my mind, because being a lawyer sometimes clouds your vision. And your place is precisely a place where you open your mind to see other things." So I have my own biases, and I need to learn to listen to people who are more open-minded or have a different perspective so I can absorb it. I don't have to agree with everything, but I think it's important to have this kind of dialogue. Excellent. Thank you very much. And
well, for those of you who stayed with us until now, I hope it was as useful for you as it was for me. A hug and see you next time. Jessica Bastos is a director at Susep, responsible for the Directorate of Market Organization and Conduct Regulation. A lawyer with a master's degree from USP and a specialization from FGV, she has worked for years on topics related to regulation, governance, and the development of the insurance market. At Susep, she leads initiatives focused on regulatory transparency, sustainability, market conduct, and the modernization of the sector. Marcelo Mansur Haddad is a partner at the law firm Mattos Filho, specializing in insurance, reinsurance, and pensions. A lawyer with a doctorate from USP and additional training in France and Germany, he has a solid track record advising companies on regulatory, contractual, and corporate matters in the sector. Recognized by international rankings such as Chambers, he also works as a professor at FGV and is a technical reference at FGV